All right, I think we're going to go ahead and get started. Just let me know in the sidebar if there are any problems with sound as we're going along. Hopefully everything is working well and everyone can hear me nice and clearly. Welcome to the live CASL Q&A, and I just want to remind everyone that along with being able to submit your questions on the side GoToWebinar bar, you can also submit your questions to us via Twitter. Our Twitter handle is @Figure8Digital. And you can tweet us your questions using the hashtag CASLQNA for us to be able to find them and ask Shaun Brown your questions during the Q&A. So, and as well, we will be doing a full recording of this webinar so that you guys can have a good resource once we're done. Without further ado, let's get started. So we're going to have Shaun go over a brief overview of what CASL is, and hopefully we'll answer some of the common questions that people usually have regarding consent, express versus implied consent, when grandfathering comes to play, how this affects some businesses that may be sending CEMs to places that are outside of Canada, and also questions regarding what exactly a CEM is. So hopefully we'll be able to touch all the bases through this 1-hour session. Before we get started, I just wanted to ask everyone a quick poll question. So if you just take a look at your screen, we're just going to have a little question pop up for you guys. So if everyone can just provide us an answer for how prepared do you feel for CASL in advance of July 1st, 2014? All right. Very interesting. It seems that most of you feel that you are somewhat prepared, so that's good. Hopefully by the end of this Q&A session, a lot more of you guys will feel somewhat to very prepared, which is what we're aiming for. I'm going to introduce you guys to today's speaker, CASL expert and Canadian privacy lawyer Shaun Brown. Shaun specializes in Canadian privacy law and has actually worked closely with the Canadian government to finalize the legislation. I also want to let you guys know that we do have some questions that we've gathered in advance through our CASL question form on our Figure8 website. So we will start off with some of those, and then as your questions start rolling in, we'll start to make sure we cover everyone's questions. If there are a few questions that are kind of similar, we're going to try to group them together just to save time, as we do only have the 1-hour mark. But without further ado, I'm going to pass it over to Shaun.
Great. So maybe we just flip to the next slide. I don't want to spend a lot of time talking about this because I think everybody here probably already knows quite a bit about CASL, and they have a good idea of what CASL is and what it does and what the main requirements are. We really want to get a chance to talk about some of the more interesting and maybe some of the more challenging issues, but just to make sure that we're all sort of working with the baseline understanding. CASL does a bunch of different things. It creates rules for sending commercial electronic messages. It creates rules for the installation of computer programs. For the purposes today, we're really going to focus on the rules that apply to sending commercial electronic messages, or CEMs, because those rules come into force on July 1 next month. The rules that apply to the installation of computer programs, we have a little bit more time. They come into force in January 15 of next year. When it comes to sending CEMs, the first question is really what is a CEM, and that really determines whether CASL applies. The concept of a CEM is defined very, very broadly. It includes essentially any electronic communication that has one of its purposes to encourage participation in commercial activity. And it also applies to various forms of electronic messaging, so it applies to things like email, instant messaging, SMS, text messaging, anything where we're sending an electronic communication to an electronic address. At a high level, we have 3 primary requirements that have to be met. First and foremost is consent. Generally speaking, we need consent before sending a CEM, and according to CASL, consent can either be express or implied. Express consent means that we actually ask for consent, and in response to a clear request and a clear purpose statement, an individual affirmatively indicates their consent to receiving a CEM. CASL also sort of sets out 4 different categories where consent can be implied, and if we fall under one of these categories, we don't actually have to ask for express consent. The first is an existing business relationship. So, for example, if someone has made a purchase or they've been a party to a written contract with a business within the last 2 years, then we have an existing business relationship. Existing non-business relationship is a counterpart that arises in the voluntary sector, or someone has donated or volunteered time to a registered charity or a political party, or if someone has been a member of a club or an association. And then there are 2 more that are really most relevant in a business-to-business context. If the recipient has provided their electronic address directly to the sender, or if the recipient has actually conspicuously published their electronic address, for example, on a website, then consent can be implied to send a CEM so long as the person hasn't published a do not solicit statement, or they haven't told you that they don't want to receive CEMs. But more importantly, any communication sent based on this form of implied consent must be relevant to the person's role in an official or business capacity. So that's really what makes this most relevant in a business-to-business context as opposed to business-to-consumer.
All right, great. Thanks, Shaun. We actually do have a few questions regarding consent, so I think we're going to start with a few of those. So the first question, hopefully everyone can hear me clearly. The first question is, if your email address is on your business card or website or other public domain source, am I allowed to contact you without your consent? As a list compiler, oftentimes email addresses are as easy to collect as phone numbers, but I would hate to not be CASL compliant as a result of our compilation methodology.
Well, yeah, that goes back to actually the last point that I made about implied consent, for example, conspicuous publication. So if you're collecting electronic addresses, for example, off the internet, the first question is, has the electronic address been conspicuously published? And that concept isn't defined in the legislation, but it implies that there's some sort of intentional act on behalf of the recipient, the person, the owner of that electronic address. So if I put it on my own website, I think that's a fairly clear example of conspicuous publication. If it's published in a directory, a public directory, that may qualify as conspicuous publication. If it's been published in like a closed directory, so something that's only available to members of a group or association, and then somehow gets published or passed on beyond the members of that group or association, I think that's less likely to qualify as conspicuous publication. So that's really the first stage. Or if someone has provided you, like you mentioned, with a business card, or otherwise provided their electronic address directly to you, like on an online form, then that means that the recipient has actually provided their electronic address directly to the sender. But again, it comes to down to that important qualification or condition that any messages sent based on that form of implied consent must be relevant to the person's business or official capacity. So this likely isn't going to be very helpful in a business-to-consumer context, because we don't really know what that person's business or official capacity is. So we have to be able to know what their business is based on how the electronic address is published or through some other means.
Great, thanks, Shaun. Does CASL prohibit list rentals? Is the next question.
No, definitely not. CASL doesn't prohibit list rentals. It doesn't really speak directly to list rentals, not sort of in the traditional sense. There are really 2 ways that list rentals, or I refer to them as list rentals versus list purchase. So a list rental, in my view, is where somebody operates their own list, so they compile it. It's based on consent. When I ask for consent for individuals who are on my list, that consent includes the ability for me to send them, for example, third-party offers. So offers on behalf of other third parties that may be relevant to certain interests. So these may be interests that they indicate on a form, or it may be obvious based on the list. So if it's a trade publication, for example, I may be sending them communications that are relevant to that particular trade. And then when I rent out that list, I offer to send somebody else's creative, their advertisement, to the individuals on my list. So in that case, this sort of list rental scenario, I never actually share the electronic addresses with that third party, and that avoids a lot of problems. It avoids potential privacy issues. It avoids potential abuse by the person who may be renting the list. So if I actually share the electronic address, I have no way of really knowing what they're going to do with those electronic addresses in the future. And there's no reason why that can't continue to happen under CASL. Again, the key considerations are that when consent is obtained up front, that consent includes the right to send third-party communications or third-party offers. When I actually send out the communications, it should be said, in most cases, you want to say that the list owner is the person who's actually sending the communication on behalf of the advertiser. A list purchase refers more to a case where someone actually buys a list of electronic addresses, and so the list owner isn't delivering to their own list. They're actually handing over the electronic addresses to the person who's making the purchase. And again, CASL doesn't prohibit this either, but it does create specific rules. And in the Act itself, this is sort of referred to as the unknown third-party rules. This means that I've actually collected electronic addresses, and at the time that I'm obtaining consent, I'm obtaining consent on behalf of an unknown third party because I don't know who I'm actually going to be sharing that list with or who may be purchasing it from me in the future. And Industry Canada has set out specific requirements in their regulations around this form of consent and how this form of consent can be used. And really the most important requirement and potentially the most challenging requirement is that anytime somebody sends out an email to a list that has been compiled based on the unknown third-party rules, so if I put together a list and I've shared it with another person, I've sold it, any communication that goes out must include an unsubscribe mechanism that allows that person to unsubscribe from all users of the list. So that includes the person who purchased the list and sent out the email, but they also have to be able to be removed from my list as well as from any other list that's been sold to another user. So a potentially complicated scenario, a little bit more difficult to comply with, but in either case, CASL definitely doesn't prohibit either list rentals or list purchases.
All right, thanks, Shaun, for the clarity on that. The next question is about implied consent. How is implied consent handled for existing customers? If a company has purchased something in the past 2 years, does the implied consent exist for anyone in the company or only for the individual who completed the transaction?
So the question is around who in the company would be able to rely on that implied consent and who would be able to actually communicate with the customer.
Exactly. I think it's more in terms of if the customer had purchased something, could it be anyone from the company that has that implied consent, or is it only the person from the company that actually made that transaction that can contact them for the 2 years?
Yeah, so there's no clear guidance or rules around this. I think it's, in a lot of cases, it's going to come down to common sense. CASL talks about an existing business relationship between a person, two persons. So the person who made the purchase and the purchase, or the person who made the sale. And the concept of a person includes more than just an individual. It includes corporations. So I think inherently we have to be able to read in the fact that if I make a purchase from an organization, I'm making a purchase from that company and not from an individual within that company. So the communications may not come from the individual salesperson who made the sale. It may come from their marketing group. And the other way around, I think, would have to hold as well. If I make a purchase on behalf of my organization, I think we have to be able to assume, within reasonable limits, that the organization who made the sale can communicate with my company. So they may not just be communicating directly with me. They may be communicating with potentially with other people within the company who are, interested or relevant in the types of products or services that they're selling. So, this is one of those areas where we don't have, and we may not have, very explicit guidance for a while. So we sort of have to, I think we have to be able to read in something that's reasonable in the circumstances.
All right, perfect. We have another question about consent. In a B2C situation, if a prospect made a quote request prior to July 1st, but not purchased, do we need to get consent again in order to email them the offers?
So if a person has made a request for a quote before July 1,
yeah,
but they didn't make a purchase before July 1, if I understand the question, it's can we respond to that quote after July 1, 2014? I don't see why. So I don't think that the time that quote came in, whether it was before or after July 1, 2014, and unless I'm missing something, I don't see why that would make a difference.
All right, up next, how does grandfathering work in terms of consent?
The concept of grandfathering has actually been sort of a long time in the making. There have been stakeholders that have been asking for quite some time for the government to come up with some sort of solution that would allow for the grandfathering of existing consent. And as a little bit of background, right now, up until CASL comes into force, and going back about almost 15 years now, email marketing has generally been regulated under our federal privacy legislation based on the theory that an email address is a piece of personal information. Privacy legislation regulates the collection, use, and disclosure of personal information in the private sector. And if you're going to use my email address to market to me, typically you need some form of consent. So for years, marketers have been getting express consent from individuals in a manner that's compliant with PIPEDA. And PIPEDA, this is our federal privacy legislation, generally establishes rules that are more flexible than those under CASL. For example, CASL says that you have to include very specific prescribed contact information anytime that you actually ask for consent. Well, of course, that wasn't required under our privacy legislation. And the concern of stakeholders was that, well, we've been following best practices for years. We've been complying with PIPEDA. We've asked for consent. We have all kinds of people on our list who provided consent. They don't complain. They like what they're receiving from us. So it's a little bit silly that all of a sudden now that CASL comes along, we have to go out and ask for consent again from these same subscribers because CASL establishes somewhat of a higher standard and creates these new rules. And so both Industry Canada, which is the government department responsible for the legislation, and the CRTC, which is the enforcement agency, have stated that for consent, express consent that's been obtained in compliance with PIPEDA before CASL comes into force, it will also be considered CASL compliant or grandfathered under CASL going forward.
All right. Our next question has to do with contest entries. If someone provides their email address and or phone number as part of a contest entry, does that give us permission to contact them if they are selected as a winner, or do we need to include a specific opt-in to be contacted if this is a scenario?
Yeah, I mean that's a good question. If someone is under PIPEDA, that would have been very easy because consent would have been implied when they provide their email address. to go back to the definition of what a commercial electronic message is, it's any message that encourages participation in a commercial activity. So if you're just sending an email to notify somebody that they've won a contest, so long as there isn't some other form of promotional or marketing content in that email, to me it seems quite unlikely that that would be considered a CEM. So if it's not a CEM, it falls outside of CASL. CASL doesn't apply. You don't need consent in the first place. That's sort of one approach. There's also subsection 6.6 of the Act, which essentially refers to a number of categories of transactional type communications, and it's been written in such a way it says that the requirement for consent does not arise for a message that solely does one of these things. And again, it's a number of categories of messages that we typically think of as transactional. Things that provide a quote or an estimate, facilitate or complete an already agreed to commercial transaction, provides information about warranty, recall, or safety information, etc., these types of things. The CRTC has interpreted to mean that those types of communications are CEMs based on how that subsection was drafted, even though they're not CEMs according to the definition. So we need to keep that in mind, that the CRTC's view is that if it falls under one of those categories, again, that's subsection 6.6 of the Act, that they are CEMs. We don't need consent, however, to send those CEMs, but according to the CRTC, we do need to meet the identification and subscribe requirements. So we'd want to think about whether that email could fall within that category of messages. But again, my sort of initial thought is I would like to think that that isn't a CEM if you're merely notifying somebody that they've won a contest, that it wouldn't be captured by CASL.
Okay, great. The next one is actually a really common one. We have a lot of people asking this one. What if I'm a Canadian company that has a combination of Canadian and American subscribers, or what if I'm unsure of their location? What other international considerations apply?
CASL says that it applies to any commercial electronic message that's sent from or accessed on a computer system located in Canada. So very simply, it applies to any CM that's sent to or from Canada. Now, there's an exclusion in the Industry Canada regulations that says if the CM is being sent with the reasonable belief that it's going to be accessed in a foreign jurisdiction and the message complies with the anti-spam legislation of that foreign jurisdiction, then CASL doesn't apply. So if you have Canadians and, for example, Americans in your database, well, based on how that's written, you technically only need to meet the CASL requirements in terms of sending to Canadians. But it is a common question about, well, I don't really know where people are because all I got on my web form was, for example, a Hotmail address or a Gmail, any sort of webmail address where we have no indication of where somebody actually resides. Well, in that case, you're kind of in a situation where you have to assume that CASL is going to apply because at least some of your subscribers are going to be in Canada. The only time you can really avoid CASL is if you actually know with I think a fairly high degree of certainty that the subscribers that you're sending to aren't located in Canada, and that can often be a difficult thing to do, especially if we're not collecting a lot of information at the time that somebody subscribes. For example, we can look at things like IP address, again, domain name. Domain for an email address, probably not very reliable. We may collect other information like a telephone number so we can look at the area code, or we may just have a country of residence field where we can actually ask somebody where they reside.
Okay, perfect. Thank you. Our next question is actually to do with social media. How does CASL apply to social media interactions? What about LinkedIn?
Yeah, there are definitely some gray areas when we're talking about social media, and I definitely don't have all the answers. There are use cases where it pretty clearly would apply to social media. There are cases where it pretty clearly wouldn't apply to social media. So examples of where CASL would apply is anytime you're using a direct messaging function through social media. So if you're sending a tweet directly to somebody's Twitter handle, so it's a direct tweet, all indications suggest that CASL would apply in that situation. If you're using an email function within, or a comparable function, for example, within Facebook, again, it's going to apply in that situation. LinkedIn is a little bit different of a situation. They have their own platform. You can send things like LinkedIn in mail. It seems to me likely that CASL would apply to those types of communications. Where CASL wouldn't apply is if we're just posting something to our own Facebook page or our own Twitter account, even though there are other people out there who may be getting updates or feeds. This is more typically referred to as a broadcast. It's not really a direct message. I'm just putting something out there. Other people have actively subscribed, and that's how they're getting access to my content. But again, the LinkedIn it's a bit of an open question exactly how it's going to apply to sending communications through platforms like LinkedIn. I think for the time being, we at least have to assume that it will apply.
Great, thank you. Our next question, does CASL require that double opt-in be used?
No, it's still good practice. But CASL just says that you have to ask somebody for express consent. So if you ask somebody for express consent on a web form, and that's it, then that's sufficient from a legal perspective. The CRTC has said through guidelines that it published at the end of 2012 that in its view, the CRTC thinks it's a good idea to send somebody at least a confirmation email saying you have been subscribed to this list, commonly referred to as sort of notified opt-in. Where double opt-in could be of assistance is CASL says that any person claiming to have consent bears the burden of proving it. So having that double opt-in, I think, provides you with even more definitive evidence that somebody has provided their express consent, because among other things, double opt-in avoids the potential hypothetical situation where somebody else actually subscribed you to a list, because you actually have to confirm via your own email. So the short answer is no, it's not. CASL doesn't require it.
All right. Our next question. Can you please elaborate on the 3-year transitional period? Does this mean we have 3 years to get our opt-in database organized? Can there be complaints before this 3-year period?
So the 3-year transitional provision, it's a little bit confusing in how it was written, and that was really put in there as a way to help people to transition their existing databases. And what that provision says is essentially if you've ever had an existing business relationship or an existing non-business relationship, so for example, if someone has ever made a purchase from you and you've been communicating with them through the use of CMs, so they've been on your list and you've been sending to them, that effectively extends the period forward to July 1, 2017. So you have to have an existing business relationship, or in some cases an existing non-business relationship. You have to have been sending them emails. I don't see why it would have to be any sort of, even if you just sent them one email before July 1, 2014, I don't see why that would qualify you. Then it's extended to July 1, 2017. It doesn't mean that your whole database is transitioned. Again, it only arises when you have an existing business or non-business relationship, and you'd want to feel comfortable that you have some sort of evidence that you actually do have that relationship. For example, the fact that they've made a purchase in the past, or they've made an inquiry. But absolutely, there's no reason why somebody couldn't make a complaint or challenge the existence of implied consent and your ability to rely on the transitional provision during that period. So it's not, it's definitely not, any form of amnesty or anything like that.
All right. Our next question is about referral. Can two businesses refer one another?
Right. So there's sort of I refer to as a partial exclusion in the Industry Canada regulations is to give you a little bit of background. This provision or this regulation was really put in there to address concerns arising largely from small businesses and professionals. So the way that CASL was written, it would make it very, very difficult, if not impossible, to rely on the use of referrals by email. And what I mean by referral is a lot of professionals rely on referrals from existing clients or friends and family in order to prospect and grow their business. For example, a financial planner may have a very satisfied customer, and that customer or client wants to refer them to their brother or a friend of theirs. How this would typically happen is the individual, the client, may get the email address of their friend or their family member and provide it to the financial planner. Well, the way that CASL is written, that would essentially be prohibited because the financial planner wouldn't have any form of consent to contact that person. So Industry Canada responded, and they included this regulation that says it's okay for a person to follow up on referral. They can send one commercial electronic message so long as the person who makes the referral, and this is an individual, has a personal, family, or existing business relationship both with the sender and the recipient. And also, when the sender sends the email or the communication, they have to identify the person who makes the referral. So this establishes an element of accountability, and they know who actually made the referral. So the sender and the recipient, they could be individuals, they could be companies. So you could refer a company to another person, but the person who makes the referral, it's notable that they're actually described in the regulations as an individual. So based on how that's written, you know that a person can be an individual or it can be a corporation. So we can refer a corporation to a corporation, but it explicitly says that the person who makes the referral has to be an individual. So in my view, that suggests that a company couldn't refer somebody to somebody else. It has to be an individual. We get into questions about, well, can that individual be somebody within a company? Well, I don't see why it couldn't be. But I think that was intentional in order, again, to sort of reduce the risk of abuse and ensure that it's really individuals who are referring people to their friends and family, and not companies who are potentially sharing your personal information with other companies.
Our next question loosely relates to an earlier question about implied consent. Does CASL apply to an email that reminds a user that his yearly membership is about to expire and prompts him to visit the website to renew it before a certain date?
There's a few considerations there. If it's prompting you to renew your subscription or your membership before a certain date, you're likely caught under the definition of a CEM. I think it would be difficult to argue that you're not encouraging somebody to participate in commercial activity because you're encouraging them to sign up for your subscription and to pay money for it. So I think you're likely captured there. Now, it doesn't mean that you can't send it. If they're an existing customer or a subscriber, well, then you would most likely have implied consent based on an existing business relationship, unless they had unsubscribed from receiving communications from you in the past.
Right. How does CASL apply to surveys on a website such as Opinion Lab?
Well, without knowing exactly what Opinion Lab is, surveys, things like surveys and contests, well, surveys in particular, if it's just a survey, there's no promotional content, it doesn't refer to an explicit product or service, I think there's definitely an argument to be made that that's not a commercial electronic message. This is going to be up to the CRTC, and I think up until now they've taken a fairly broad approach to interpreting the definition of a CEM. If it does start to include references to products and services, or the survey is highly branded, then you're definitely increasing the risk that it's going to be considered a commercial electronic message. And then, of course, if there's any explicit ask or promotion or anything included in the survey, then it's definitely going to be considered a CEM.
Next question. If a contact list is provided by an organization that is speaking on behalf of or representing a large membership base, is that considered consent?
So the question there is if an organization could essentially consent on behalf of all of its members or people who are on the list. That's another good question. I don't know the answer to that. At minimum, I would say there's definitely some risks in relying on that. So if an organization, for example, industry or a trade organization were to hand over their list to you, I would want some comfort before I sent any messages to individuals on that list that they had provided some form of consent, or that at minimum the organization had the authorization to share that list with anyone who was going to send to it. Because I think, depending on the circumstances, the organization, the types of products and services that might be marketed, potentially even the size of the organization, those are all things that are going to potentially influence the risk factors. But I would definitely be careful in that situation.
What about platforms such as Kijiji and soliciting someone to use your services to assist them in their item for sale?
That sounds pretty clear to me that would be a commercial electronic message. I guess I'm not exactly clear on the circumstances. If I contacted somebody who had posted something on Kijiji, I don't see why that wouldn't be a CEM.
I think it's more so if an individual is posting something to sell on Kijiji and they are sending the message to the buyer through the Kijiji messaging platform, would that be considered soliciting to someone?
It would definitely be commercial. I guess without really knowing the details of that platform, the question would be whether, less about whether it's commercial, more about whether it would be an electronic message sent to an electronic address for the purposes of CASL, and that's where I think you'd have to focus the analysis, and I don't know the answer to that question.
All right. We're going to move on to identification. Whose information needs to be identified on the offline opt-in?
Could you clarify that? On an offline opt-in, so do you mean like a paper form or a ballot or something like that?
I think this would be when someone was filling out an offline form. For example, if you were in a retail store, what kind of identification info would the company need to provide there?
Between CASL and the CRTC regulations, that any time we ask for express consent, we have to identify the person asking for consent. So the name, this is typically going to be the company name, and a physical address, and any one of an email address, a URL, or a telephone number. So all those things would have to be included, whether it's an online web form or a paper ballot or paper form that's being used at the point of sale in a retail environment.
All right, next question. For CEMs such as a newsletter, do we need to show our business's postal address, or is a link to the website where the address is displayed considered good enough?
Well, there's probably a little bit of room for question interpretation on that issue, but my understanding and the approach has been that needs to be actually included in the email itself. I haven't seen any guidance to suggest that you don't need to include that identification information in the email itself. And in particular, when we're dealing with email, it's not, I don't believe it's particularly onerous. For example, most sending platforms have the ability to create an automatic footer that's included at the bottom of every communication, so it can be included there. But the CRTC does say if it's not practical to include the information in the message itself, we can include it in a link. And the most obvious case where this would arise would be with an SMS text message when we have a very limited number of characters. So the CRTC has said that it's okay in those cases, but I would expect that they would say that when you're dealing with email where you have sufficient space, that it has to be in the message itself.
All right, thanks, Shaun. We're going to go and move on to some questions regarding unsubscribe mechanisms. First question, for an existing email list where previous express consent is unclear, do I need to send out an email asking for them to re-consent, or is having the unsubscribe option on each email adequate?
So for an existing list, do you need to reconfirm? Well, the unsubscribe, the fact that you have an unsubscribe mechanism in the messages that you're sending out has no bearing on the question of whether you need to reconfirm. The question of whether you need to reconfirm is based on whether you have some form of consent. And as we talked about, do you have express consent that's CASL compliant? Do you potentially have express consent that's PIPEDA compliant and therefore grandfathered? Or do you have implied consent and possibly able to rely on the transitional provision? So simply including an unsubscribe in your email can't sort of get you out of that tough question of deciding whether you need to reconfirm.
Thanks, Shaun. Next question. I thought I had read somewhere that there will be a few months grace period after July 1st. Is this true? If so, how long is the grace period?
I'm not familiar with any reference to a grace period. That would be new to me. I don't believe that there is any such thing. The law comes into force on July 1, 2014, and it could be enforced on day one, unless there's been something that I'm not aware of.
We actually have a question that came in through Twitter. If a trade show provides a list of attendees, contact info to exhibitors, do we still need to get their consent?
Yeah, this question comes up a lot, and there are a number of considerations here, but as an exhibitor, you need to know that there's some form of consent that you can rely on. And I think generally speaking, what's going to be required is that if someone who's putting on a trade show or a conference or an event wants to be able to offer the attendee list as part of its value proposition to exhibitors or sponsors, they're going to need to get consent from the attendees. It's arguable that an event organizer or a conference organizer would have an existing business relationship with those attendees because the attendees have made a purchase from them, for example, and that would allow the organizer to communicate with them directly, for example, about future events. But there's nothing, and I think it's unlikely that you would be able to rely on that implied consent to then provide the list to exhibitors. So again, organizers are going to have to get some form of consent from attendees, and most likely it's going to need to be express consent, so we're going to have to ask them, and they're going to have to opt in to receiving communications from exhibitors.
Thanks, Shaun. We've actually had a lot of questions come in about consent, so if no one minds, we're just going to go back and address the rest of these questions. The next question is, when signing up on a web form, does asking for an email address suffice express consent? Or does there need to be a separate checkbox to state that they will receive email communications?
Duran, do you have the slide in there that shows the CRTC examples? Do you have that in there? Yeah, just pop that up. So I think the short answer is no, and the CRTC has actually provided some useful guidance on this, and these are shrunk down a little bit, so they're a little bit hard to read, but the point is that the CRTC has said that pre-check boxes aren't okay. They provide an example of a pre-check box, and there's an X through it. An unchecked box, that one's okay, but then the sort of third option, and this makes a lot of sense, is that if you actually have to enter your email address into a field and click submit next to a clear purpose statement, well, that's sufficient evidence of express opt-in consent in the CRTC's view. So where this is likely to be used is if you don't already have the person's email address, and that's all they're doing is signing up to your list. This may not be as relevant. For example, we're going to use a checkbox when we already have the individual's email address, it may be at the bottom of a form where somebody had to create an account or make a purchase, so they've already provided it for those purposes. And then before the submit button or the checkout, we also want to get their express consent. And in that case, we need the checkbox. And according to the CRTC, it has to be unchecked.
Great. Thanks, Shaun. Next question. I'm not familiar with PIPEDA since this is an important factor when considering pre-July 1st subscribers. Is there a high-level way to describe the requirements for us?
Yeah, so PIPEDA, again, it's the Personal Information Protection and Electronic Documents Act. It's federal privacy legislation. And PIPEDA says that, generally speaking, businesses need some form of consent before they can collect, use, or disclose personal information in the course of commercial activity. And again, that applies to email marketing, and that an email address is generally considered personal information. If I'm sending you marketing communications, that's a use of your personal information, and I need consent for that. Now, getting back to what the standard is under PIPEDA and the differences between PIPEDA and CASL. Well, again, the one big difference is that CASL establishes these specific requirements. So you have to tell the person they can unsubscribe. You have to include a mailing address, for example, when you ask for consent. PIPEDA doesn't require that. It's more flexible. The other difference, and this is where things get a little bit more complicated, and I can tell you there's been a lot of time spent discussing this issue, is that generally speaking, under PIPEDA, we don't need opt-in consent in order to market to somebody. The Office of the Privacy Commissioner of Canada has said that it's fine to rely on opt-out consent so long as a few conditions are met, one of which is that the collection, use, or disclosure of personal information doesn't involve sensitive information or sensitive use. So in most cases, if we're signing somebody up to an email list, for example, we could use a pre-checked box. That would be fine under PIPEDA. Where it wouldn't be okay, one possible example is if someone was signing up to receive information about a medication related to a very sensitive medical condition. In that case, arguably, we're engaging in something that's more sensitive, and the OPC might say that we actually need to use opt-in consent, so no pre-checked boxes. As a general rule, again, pre-check boxes are okay under PIPEDA. The next question then is, well, will pre-check boxes be transitioned or grandfathered under CASL? And again, there's two ways of looking at this. Both the CRTC and Industry Canada have explicitly referred to grandfathering of existing express consent. And when you look through Privacy Commissioner guidance, a pre-checked box, in my view, a pre-checked box is just another form of express consent. It's opt-out express consent as opposed to opt-in. But the Privacy Commissioner, at least that I'm aware of, has never actually referred to this as express consent. They refer to it as sort of negative option or opt-out consent. So there is a bit of an open question about whether pre-checked boxes will be grandfathered under CASL, and the CRTC has never given a clear answer on this. Their response is usually that, or at least that I'm aware of, their response is that we will grandfather existing express consent. I don't think it's in their interest, or I don't see them making a big deal out of the fact that somebody may have used a pre-checked box, as long as it's otherwise PIPEDA compliant and it's clear to the individual and they've been receiving communications and they haven't complained. But based on what we know, or at least what I know has been publicly said, there still is a bit of an open question about whether pre-checked boxes will be grandfathered under CASL.
All right, our next question. I have a newsletter email list with several thousand emails. I was not part of the creation of the list, and it's stored on an email platform, and it was uploaded from an Excel file. I don't know how these emails were obtained. Do I need to send out an email to these addresses requiring their express consent?
Well, I guess the answer to that question depends on a few things. Generally speaking, if you don't know where email addresses came from, that's definitely one factor in favor of reconfirming. Typically, you're going to have some idea of where they may have come from. For example, are they likely to have been past customers? If so, you may be okay under implied consent in the transitional provision. Did they come in through one of your web forms? Did they sign up? Did you have web forms in the past, or do you think that those electronic addresses were bought? So was this through a list purchase? And if it was through a list purchase, chances are you're not going to have any form of consent, and that's where you may have to actually go out and reconfirm these subscribers. And also think about your comfort level that if there was an investigation, that you'd be able to show where those electronic addresses came from. And again, it sounds like you may not be able to do that. So that sounds more like a situation where you may ultimately need to go out and reconfirm those subscribers before July 1.
Thanks, Shaun. Next question. Are you able to make the opt-in checkbox a required field? Are there any rules against that?
Yeah, that's another good question. There's some guidance on that issue. So the CRTC has said that providing consent to receive CEMs can't be required as a condition of purchase or use of a product or service. And this is generally consistent with commonly referred to as the refusal to deal requirement under privacy legislation that says that we can't require somebody to consent to a use of their personal information that isn't necessary for the purposes of providing a product or a service. Where things get a little bit more murky, and I think there has to be, I would like to see some allowance for this being a mandatory field, is situations where we offer something for free, so maybe a contest or a promotion, and I kind of see that as the trade-off that, in order to get this free thing, for example, it might be a white paper. The trade-off is that you're giving us your email address. I would like to think that that's okay. We don't have really clear guidance either way, which makes it a little bit complicated. The one thing that is clear, even if it is a mandatory field and you feel comfortable that that's acceptable, you do have to still give them the ability to unsubscribe. So at most, they could be required to receive one email if they unsubscribe right away. Again, it's a good question, and it's something I think we're going to have to wait for guidance on that issue.
Thanks, Shaun. One last question here. Who's going to police all of these rules, and what are the penalties?
The CRTC is the police for now. The Canadian Radio, Television and Telecommunications Commission is the enforcement agency under CASL. There's also private right of action that allows any person who's affected by a violation to file a lawsuit in court. However, that particular aspect of CASL has been delayed until July 1, 2017, just given the enhanced risks and uncertainties around how it might be leveraged. So at least until July 1, 2017, it's solely up to the CRTC to do investigations and enforcement. They actually have the ability to impose administrative monetary penalties of up to $10 million per violation. Now, I would expect that anything even close to that amount is going to be reserved for some of the worst violations out there, i.e. people who are actually spamming, knowing and intentionally spamming. But it's really up to the CRTC to enforce this, and it's going to be, we're going to have to wait to see to how aggressive they are and what sort of violations or issues that they're going to be most interested in. But I'd like to think, and we have no reason to believe that they're not going to take a common sense approach to this, and that I haven't seen any suggestion that it's their goal or their intention to go out and try to punish legitimate businesses who are really just trying to do the right thing and trying to comply with the legislation.
All right, thanks so much, Shaun. We had a lot of questions come in, and if we weren't able to get to your question today, you can definitely feel free to visit our website and the CASL resource page, and feel free to reach out to us even through our Contact Us form, and we'll be able to get back to you and with any answers that you may need. But before we let you guys all go, we just wanted to ask you guys one more time a quick poll question of how prepared you feel for CASL now that we've had our Q&A session. So I'm just going to launch a quick poll here and ask for everyone's participation. All right, thanks everyone for your answers. Really interesting percentage. The percentage of very prepared at the beginning of this presentation and to the poll that we just did right now, the percentage is actually doubled, so that's really great. We're really glad that everyone was able to get some clarity on some of the questions that they had about CASL today. Just want to thank everyone for participating and listening in on our Q&A. And again, if you have any other questions that we weren't able to get to, feel free to contact us, and we will make sure that everyone that attended today will get the full recording of this Q&A. And thanks a lot, Shaun, for answering all of the CASL questions. I'm sure you feel a little bombarded.
Well, thanks for having me. It was fun.
Awesome. All right. Thanks for joining us, everyone. Have a good day.